all of this. Joining us, Democratic Congressman Adam Schiff. He's the top Democrat, the ranking member of the House Intelligence Committee. Congressman, thanks so much for joining us. You reacted to all this today by tweeting this, and let me read from your tweet. Michael Cohen made the right decision to cooperate with the special counsel's office. His sentencing today demonstrates that nobody is above the law, not the personal lawyer to the President of the United States or the President himself. As you know, the President has been implicated in the crimes for which Michael Cohen is now going to prison. So how do you think the President will be held accountable?
Well, I think the more significant development in the case today than the sentence that Michael Cohen received was the fact that there's this non-prosecution agreement with AMI, that parent of the National Enquirer, because what that means is this is not simply Michael Cohen's word against Donald Trump's. It is now Donald Trump's word against everyone else, that there are witnesses at AMI who will testify these payments were made for the express purpose of influencing the election by depriving voters of knowledge of these stories of women coming forward to say they had affairs with the candidate for the president. That is powerful corroboration. There is apparently another witness within the Trump organization that also corroborates what Michael Cohen has to say. So that, to me, is the most significant development. And I would say this on that statute of limitations question that you mentioned, Wolf, and that is, I think the Justice Department needs to re-examine that OLC opinion, Office of Legal Counsel opinion, that you cannot indict a sitting president under circumstances in which the failure to do so may mean that person escapes justice. Because if it were the case that it was now or never, that if you wait until after the president leaves office, they can no longer be brought to justice, that ought to create certainly an exception to that OLC rule, if not mean revisiting and revising the rule altogether.
So am I hearing you correctly? You say indict him now and maybe try him after he leaves office? Is that what I'm hearing?
Well, what I'm saying, Wolf, is I don't think that the Justice Department ought to take the position, and it's certainly not one that would be required in any way by the Constitution, that a president merely by being in office can be above the law, can escape the enforcement of the law by essentially waiting out the law, by waiting out the statute of limitations. So there ought to be a mechanism to make sure that that is not the case, whether that means revisiting the OLC opinion that, and allowing the indictment of a sitting president and staying the prosecution, or allowing both the indictment and prosecution. But I think those issues may be foursquare before the Justice Department. Now, the department may wish to wait to resolve those issues to determine whether they're ripe, in the sense of that may not be an issue if the president is not reelected. But I think that now is something that the Justice Department needs to consider.
Because I remember on Sunday you suggested that he should be indicted potentially after he leaves office and not necessarily while he's still in office. What changed between Sunday and now?
No, I wasn't saying the president should be indicted when he leaves office, but it seems to me that it is very likely that Bob Mueller will adhere to this OLC opinion, that he will make the judgment that while the Constitution doesn't prohibit him from seeking an indictment, that there are prudential reasons why he might not do that, that he would follow this precedent set by the OLC. But if there is an issue about whether justice can be had after he leaves office, I think that ought to get the Justice Department to examine whether either an exception to that policy is necessary or whether a reconsideration of that policy is in order.
The prosecutors said today that AMI, the parent company of the National Enquirer, made that hush money payment in cooperation, consultation, and concert with and at the request and suggestion of one or more members or agents of the candidate's 2016 presidential campaign. That's a direct quote. So what might AMI be able to reveal about President Trump's role in all of this?
Well, that's really the million-dollar question, and that is, did AMI, its officers, have direct contact with Donald Trump about this? Were they part of the conversations where they either offered or the president solicited the help that they provided in capturing and killing these stories? So was that, were they part of direct conversations, direct communications with Donald Trump? That would obviously be the most powerful evidence. Or were they in communication with others in the Trump organization that would corroborate Michael Cohen?
the head of AMI, and we've been showing our viewers some pictures of David Pecker. He has an immunity agreement in exchange for his full cooperation. Allan Weisselberger, the chief financial officer of the Trump organization, interestingly, also has an immunity agreement in exchange for his full cooperation. And there's been a sense, at least among some that I know, that Weisselberger, he knows a lot. He knows everything that was going on. Is he a big deal potentially?
Well, he certainly could be on great many issues. This hush money payment, considering that it is alleged that he had a role in that. But it may also be that with respect to other information Michael Cohen can provide about the Trump organization, about the effort to make this Trump Tower deal in Moscow, or other financial entanglement with the Russians, you would imagine that the CFO, the chief financial officer, or the accountant for the organization itself may know where the financial bodies are buried. So he could be obviously a very key witness.
As we've been discussing, you've said that the president could be indicted while he's in office, after he leaves office, related to the Michael Cohen crimes. But the president told Reuters last night that he was simply relying on his lawyer, namely Michael Cohen, and that there was no violation, he said, because the payments were civil. What do you make of that defense?
I don't make much of it, honestly. Given the nature of the discussions, I think there will be ample opportunity for the department, if it pursues this, to demonstrate that the president knew what he was doing was wrong, knew what he was doing was unlawful, and was prepared to do it anyway. What we have found consistently, Wolf, is you can't rely on any of the president's representations because, of course, he said he knew nothing about this. He had no discussions with it. Now we know that all of that is false. He said when the sentencing memoranda came out that essentially, thank you, that has completely vindicated me, when it was quite the opposite. So the last person we can rely on this is Donald Trump. But nonetheless, the department needs hard evidence. They may very well have it. And I think it's vitally important that the department adhere to the principle no one is above the law. And all of the arguments they made against Michael Cohen, all the arguments they made as to why the seriousness of this offense justified his going to jail, that the rich and powerful don't operate by a set of different standards as those that were walking precincts or putting bumper stickers on their car or making calls, all of those arguments apply with even greater force to Mr. Trump.
Very quickly, our last question, Congressman. Cohen is scheduled now to begin his prison sentence in early March. You're going to be the chairman of the House Intelligence Committee. Are you going to call Cohen to testify before your committee before he starts that prison sentence?
We are already in touch with his counsel. We're very eager to have him come and testify. I was very pleased to see today that one of his lawyers issued a statement saying that he is more than willing to come and cooperate and share what he knows with us, and we certainly intend to take him up on that.
Publicly, will he appear before the cameras?
You know, we'll have to make a decision on a case-by-case basis, which interviews are conducted in open session and which in closed session. That may be the product of some internal discussion and debate or agreement with witnesses, depending on the circumstances. So at this point, I can't say.
Well, we're voting for open session with the cameras there, as you probably